All right, welcome back to another episode of Mike Reads. Tonight we'll be continuing in our series on Thomas Sowell's Discrimination and Disparities with our second read in Chapter 2 entitled Discrimination, Meanings and Costs. We will begin tonight with the subsection, Costs of Discrimination. Neither the amount nor the severity of discrimination is fixed permanently. It varies greatly from country to country and from one era to another in the same country. There was an era in which many American employers' advertisements for some jobs said, "No Irish need apply," or "Whites only." There was a time when some shops in Harlem, back when that was an upscale white community, had signs that read, "No Jews and no dogs." Nor were Americans unique. In many other places and times around the world, group discrimination, that is, discrimination too, was so pervasive and so widely understood that no such signs were necessary. For a woman, a Jew, or members of some other groups to apply for certain jobs would have been considered a presumptuous waste of the employer's time. Discrimination, too, in hiring and promotions raises questions about both causation and morality. Both kinds of questions deserve to be examined separately. Causation. In trying to understand the causes and consequences of discrimination in hiring and promotions, it is necessary to again consider whether this is discrimination 1 or discrimination 2. This is not always an easy question to answer, and in fact easy answers such as automatically equating statistical disparities in outcomes with discrimination 2 can be a major obstacle to getting at the truth. An employer who judges each job applicant individually without regard to the applicant's group membership can nevertheless end up with employees whose demographic makeup is very different from the demographic makeup of the local population. One major demographic fact that is often overlooked by those who automatically equate statistical disparities in outcomes with discrimination too is that different ethnic groups may have very different median ages. Japanese Americans, for example, have a median age more than 2 decades older than the median age of Mexican Americans. Even if every individual of the same age had the same incomes, regardless of which group that individual was part of, nevertheless there would still be serious disparities in income between Japanese Americans and Mexican Americans, as well as between many other groups. A group with a median age in their 20s will obviously not have nearly as large a proportion of their population with 20 years of work experience as a group whose median age is in their 40s. One group may therefore have a disproportionate number of people in high-level occupations requiring long years of experience, while the other group may be similarly overrepresented in entry-level jobs, in sports, or in violent crimes, which are all activities disproportionately engaged in by the young. Such disparities in outcomes are not automatically evidence of either outsiders' biases or internal deficiencies in the groups. Either or both may be present or absent, but that requires specific empirical evidence going beyond gross statistical differences in outcomes. In short, conditions prior to job applicants reaching an employer can have a, quote, disparate impact, end quote, on the chances of someone from a particular group being hired or promoted, even if the employer judges each applicant on that applicant's own individual qualifications without regard to the group from which the applicant came. Age is just one of those pre-existing conditions. As already noted, children raised in families where the parents have professional occupations hear nearly twice as many words per hour as children raised in working-class families, and more than 3 times as many words per hour as children raised in families on welfare. Can we believe that such differences, and others, compounded over many years while growing up, make no difference in individual abilities and social outcomes when those children become adults seeking employment? All these individuals may have been very similar at birth, but many things happen between birth and applying for a job or for college admissions. And it seldom happens the same for everybody. As we have seen, it happens differently for children born and raised in the same family who happen to have been born earlier or later. Not only differences in child rearing, but also decisions made by individuals themselves affect their outcomes. When more than 3/4 of all college degrees in education go to women and more than 3/4 of all college degrees in engineering go to men, the statistical predominance of women in teaching and men in engineering cannot automatically be attributed to employers' biases. More fundamentally, the cause of a given outcome is an empirical question whose answer requires untangling many complex factors rather than simply pointing dramatically and indignantly to statistical disparities in outcomes, as so often happens in politics and in the media. Costs and their effects. It is easy to understand how being denied an opportunity to be hired or promoted for some jobs can lead to some groups having lower income than others, and why that can arouse moral objections, not only from those denied jobs, but also from others who find such practices morally repugnant. From a causal perspective, other questions arise as to the reasons for such practices. Here, the cost of discrimination to the discriminator plays a causal role in the outcome. There is also a cost for society at large. A society in which women are arbitrarily banned from many kinds of work can pay a huge cost by forfeiting the productive potential of half its population. Society, however, is seldom a decision-making unit, except perhaps at election time or during a mass uprising. To understand decisions in general, or employment decisions in particular, requires understanding the incentives and constraints confronting the particular decision-makers in particular kinds of institutions, who cannot simply choose to do whatever they wish without regard to the costs of their decisions to themselves. In a competitive market for labor, or for the sale of employers' products, the validity of the beliefs behind a business owner's decisions can determine whether that business operates at a profit or a loss, and whether it survives or is forced to go out of business. In short, we cannot simply go directly from attitudes to outcomes, even if these attitudes involve racism or sexism, as if there were no intermediate factor or costs for decisions made in a competitive market. A systemic analysis of markets cannot proceed as if there were no other factors involved besides what individual decision makers happen to prefer. Economists who have recognized this have ranged from the followers of Adam Smith to followers of Karl Marx. The point was perhaps best expressed by Friedrich Engels, co-author with Marx of the Communist Manifesto. Engels said, "What each individual wills is obstructed by everyone else, and what emerges is something that no one willed." An analysis of systemic causation is concerned with what emerges. Adam Smith, patron saint of free market capitalism, likewise had a systemic analysis of causation. He did not attribute the benefits of a capitalist economy to good intentions by capitalists. On the contrary, a case could be made that Adam Smith's view of capitalists as individuals was even more negative than that of Karl Marx. Smith and Marx reached opposite conclusions as to the benefits or harm done by free market capitalism, but neither based his conclusions on the intentions of capitalists. Each based his conclusion on the systemic incentives and constraints of economic competition. Too many other observers, including some academic scholars, reason as if intentions automatically translate directly into outcomes. Thus, in his book, The Declining Significance of Race, sociologist William Julius Wilson pointed out the various organized ways in which white Southern landowners and employers in the post-Civil War South sought to keep down the earnings of black workers and black sharecroppers. But there was no reference in that book to empirical evidence on how those intentions actually turned out. In other words, quote, what emerges, end quote, as Engels put it. By contrast, economist Robert Higgs, who researched the actual consequences of those efforts of white employers and landowners in the postbellum South, found that such organized efforts often collapsed as a result of the competition among white employers and landowners for black workers and sharecroppers. It might seem as if newly freed blacks, desperately poor, often illiterate and unfamiliar with working as free people in labor markets, would be easy prey for whites united to enforce whatever wage and sharecropper conditions they wanted. But to expect such opportunities to prevail continuously ignores the inherent systemic competitive pressures in a market economy. In agriculture especially, and the South was largely agricultural at that time, there is an inherent urgency about getting the land plowed and the seeds planted in the spring, or else there will be no crop in the fall. Those white landowners who were the first to violate the terms to which other white landowners sought to limit the economic benefits to black workers and sharecroppers stood to be the first to assure themselves of a workforce sufficient in both quantity and quality to maximize the size of the crop that could be grown on a given piece of land. Other white landowners who stuck by the restrictions and/or who cheated the black workers and sharecroppers in various ways tended to find themselves having to make do with whatever quantity and quality of black workers and sharecroppers remained, after other white landowners had skimmed the cream by paying higher wages and higher crop shares to improve their own prospects of a profitable crop. It is hardly surprising that organized efforts at suppressing black workers' pay and black sharecroppers' shares of their crops often broke down under such economic pressures. What emerges in this case was that black incomes per capita in 1900 were, at a minimum, almost half again, higher than they had been in 1867 to 1868. This represented a rate of growth higher than that in the American economy as a whole during that period. Because they started from a far lower economic level, blacks were still poorer than whites. But Professor Higgs' data indicated that, quote, black incomes grew more rapidly than white incomes over the last third of the 19th century, end quote. And about 90% of blacks lived in the South during that era. Businesses in general, whether making decisions in a labor market or a product market, are not like professors voting at a faculty meeting, because those votes seldom have any costs for the professors themselves, despite whatever good or bad results such votes may have for students or for the academic institution. The difference is the difference between decisions made subject to consequential feedback in a competitive market and decisions made with insulation from such feedback in academia and other insulated venues. South Africa under apartheid. To avoid endless and inconclusive debates about the presence or magnitude of racism, we can test our hypotheses about the cost of discrimination in a context where there is no ambiguity on the subject, namely, South Africa during the era of apartheid, ruled by a white minority government, elected with the black majority denied a vote, and openly promoting white supremacy. Apartheid laws unlimited how many blacks could be employed in particular industries and occupations, and forbade their being hired for work above certain levels in those industries and occupations. Yet white South African employers in competitive industries often hired more blacks than they were allowed to under apartheid laws, and in higher occupations than those laws permitted. A government crackdown during the 1970s led to hundreds of firms in South Africa's construction industry being fined for violating those laws. Nor was the construction industry the only one in which competitive businesses were fined for hiring more blacks, and in higher occupations than allowed under the law. In some other industries, blacks even outnumbered whites in some particular job categories where it was illegal for blacks to be hired at all. There is no compelling evidence that the white employers violating those laws had different racial views than the white legislators who passed such laws. What was different was that employers who failed to hire black workers, whom it was profitable to hire, paid a price for discrimination too, in the form of lost opportunities to make money, while the legislators who passed laws imposing discrimination too paid no price at all. Indeed, legislators who failed to pass such law would pay a price politically in a situation where only whites could vote and where white workers wanted protection from the competition of black workers. Both the employers and the legislators were rationally pursuing their own self-interests. It was just that the institutional incentives and constraints were different in a competitive market from the incentives and constraints in a political institution. Nor were labor markets the only markets affected by the costs confronting discriminators in South Africa. Apartheid laws made it illegal for non-whites to live in certain areas set aside by law for whites only. Yet many non-whites in fact lived in those whites-only areas. These included Black American economist Walter E. Williams during a 3-month stay in South Africa doing research. There was at least one whites-only area in South Africa where non-whites were a majority of the residents. Here again, costs are the key. The cost to those owners of rental property in whites-only areas who forfeited economic benefits available by refusing to rent to non-whites competed with the cost of disobeying apartheid laws, and the latter did not always prevail. While racists, by definition, prefer their own race to other races, individual racists, like other people, tend to prefer themselves most of all. That is what led to widespread violations of apartheid laws by white employers and landlords in competitive industries in South Africa. It costs nothing for white South Africans to vote for candidates promoting white supremacy. But the cost of refusing to hire black workers who would make their own business profitable could be considerable. Moreover, the costs of refusing to hire blacks when other businesses competing in the product market were hiring them risked having competitors with lower prices be a threat to the survival of a business operating in a competitive market. This is not to say that discriminatory laws and policies have no effect. There are costs to disobeying laws, as well as countervailing costs to follow such laws, so outcomes depend on particular circumstances in particular times and places. The costs of discrimination, too, can be far lower, or even non-existent, in situations where free market competition does not exist, such as in 1. Public utility monopolies whose prices and profit rates are directly controlled by government, 2. Non-profit organizations, and of course, 3. Government employment. In all these particular situations, discrimination too has tended to be far more common than in competitive markets, not only in South Africa under apartheid, but also in other countries around the world. Unless one believes that decision-makers in these particular institutions have different racial or other views than decision-makers in competitive markets, and that such differences persist over time as new generations of decision-makers come and go, the reasons for such institutional differences must be sought in particular incentives and constraints growing out of differences in circumstances of those institutions. Let's see. Okay, we'll continue. Institutional incentives and constraints. One of the landmark struggles in the civil rights movement in mid-20th century America was a campaign against laws in most southern states mandating that black passengers sit or stand in the back of buses, with the seats up front being reserved for whites. Although many people on both sides of this struggle regarded those laws as though they had existed from time immemorial, they had not. The history of such laws illustrates again the different roles of economic incentives and constraints versus political incentives and constraints. 3 decades after the end of slavery, laws mandating racially segregated seating in municipal transit vehicles began to be passed in many southern communities toward the end of the 19th century. The political situation had changed from that in the period immediately after the Civil War, when U.S. troops were stationed in southern states, and southern governments were subject to federal policies granting blacks the right to vote during what was called the Reconstruction era. With the end of Reconstruction and the return of local self-government in the South, blacks often lost the right to vote by methods ranging from laws to organized terrorism. Racially segregated seating on municipal transit vehicles was just one of the political consequences. Before these laws were passed, it was common for blacks and whites to sit wherever they felt like sitting on public transportation vehicles in the South. Many, if not most, of the bus and trolley companies during the era were privately owned, and their profits depended on how many people, whether black or white, chose to ride in their vehicles. The decision makers in these privately owned companies understood that they could lose profits if offending black customers by making them sit in the back, or to stand when all the black seats were taken, even if there were vacant seats in the front section that was reserved for whites. Indeed, racially segregated seating could even offend some whites when all the white section seats were filled but there were vacant seats in the section set aside for blacks. In short, racially segregated seating in municipal transit vehicles was seen by those who owned or managed such companies as something that reduced profits. Not surprisingly, municipal transit companies in the South fought against the passage of laws requiring racially segregated seating in buses and trolleys. After losing politically in the legislatures, municipal transit companies then took the issue into the courts, where they lost again. And, after the laws went into effect legally, many Southern municipal transit companies simply did nothing to enforce racially segregated seating. In many places, both black and white passengers continued for years to sit wherever they felt like sitting. Eventually, however, Southern government authorities cracked down. They began charging municipal transit company employees with violations of the law for not enforcing racially segregated seating, and in some cases the owners of those companies were threatened with prosecution if those transit lines did not enforce the racial segregation laws. Only then did the laws that had been passed, in some cases years earlier, finally get enforced. Railroads were also affected economically by racial segregation laws. When black and white passengers had to be carried in separate coaches, this imposed the considerable cost of buying additional coaches for their passenger trains, as well as the further additional cost of more fuel to move the now heavier trains. This was especially costly when there were insufficient passengers to fill one coach. If there were only enough black and white passengers to fill the total for 2/3 of the seats in a coach, racial segregation laws could create a situation where there were now 2 coaches required, each with only 1/3 of the seats occupied. Like municipal transit companies, railroad managements in the South opposed the racial segregation laws in their own self-interest, even if their racial views might not have been any different from those of the politicians who passed such laws. But the incentives to which the politicians responded were votes, that is, white votes, while the incentive to which railroad owners and managers responded were financial, and money was the same, regardless of the racial source. The famous Supreme Court case of Plessy v. Ferguson in 1896 arose from the cooperation of the railroads with Homer Plessy, who was challenging these racial segregation laws in order to create a test case. Although Plessy was part of the black community, he was genetically far more Caucasian than African and was physically indistinguishable from white men. Had he simply gotten on a train and ridden to his destination, there was little likelihood that he would have been questioned about being seated in a railroad car set aside for whites only. But the attorneys for the railroad and the attorneys for Plessy cooperated in arranging a legal confrontation so that there would be a case to take into the courts. Unfortunately for both, and for the cause of equal rights in general, the Supreme Court majority ruled against them. There is no predestined outcome of the conflict between economic and political forces. What is important is to recognize the implications of that conflict when crafting or changing laws and policies. It is not only in political institutions, but also in some economic institutions that decision makers are insulated from having to pay the costs of discrimination too. Public utility monopolies, whose prices and profit rates are directly controlled by government regulatory agencies, are among the institutions insulated from paying the economic costs which a competitive market imposes on discriminatory behavior, whether directed against ethnic minorities, women, or others. Although engaging in discrimination too and hiring employees could mean lower profits for a firm operating in competitive markets, a government-regulated public utility that has a monopoly in its market would not be allowed to earn a higher profit rate than the government agency deemed proper in any case. So a regulated public utility company is not forfeiting any additional profit that would be allowed to keep that it would be allowed to keep if it hired without regard to the group from which the job applicants came. Discrimination, too, might require the regulated public utility company to pay additional labor costs because of having to offer higher salaries in order to attract a larger pool of qualified applicants, from which only applicants from groups that the decision makers preferred would be hired. But for a government-regulated monopoly, such costs can be passed on to customers who have little choice but to pay those costs. The history of the telephone industry, back when telephones meant landlines, and all the major phone companies in the United States were subsidiaries of the American Telephone and Telegraph Company, illustrates this pattern. As of 1930, there were only 331 black women in the entire country working as telephone operators, out of more than 230,000 women in that occupation. As late as 1950, black women were still only 1% of all women working for phone companies. However, after creation of, quote, fair employment practices, end quote, laws in some northern states in the 1950s, and then federal civil rights laws and policies in the 1960s, many telephone companies reversed their policies, and blacks began to be hired disproportionately. Prior to the 1960s, however, the state, quote, fair employment practices, end quote, laws existed solely outside the South. Although a national sample of employment in the telephone industry showed that the employment of black telephone operators increased more than threefold between 1950 and 1960, it was 1964 before the first black telephone operator was hired by phone companies in such southern places as New Orleans, South Carolina, or Florida. Meanwhile, data from a national sample of telephone companies showed that blacks accounted for 1/3 of the total growth in these companies' employees from 1966 to 1968, a trend that had begun in the 1950s and was concentrated mainly in northern and midwestern companies. But in the South during the 1950s, in all 11 states that had once formed the Confederate States of America, the share of blacks among male employees of the telecommunications companies actually declined. Since all these phone companies were owned and controlled by AT&T, such sharp regional disparities in individual phone company policies were far more consistent with regional differences between southern and non-southern state governments that regulated these companies than with policies handed down from AT&T's national management. What was consistent in all these various regions was that additional costs entailed by either preferential or discriminatory treatment of black job applicants were costs that phone companies could pass on to customers who had little choice but to pay them, since there were only landlines at the time, and each phone company was a monopoly in its own area. It was much the same story in government-regulated oil and gas public utilities at that time, where that regulation was also by state agency, and increased hiring of blacks was confined to states outside the South during that era. These companies, too, paid no costs for discriminating against blacks before, nor any cost for preferential hiring of blacks afterwards. The same was true of decision-makers who ran nonprofit organizations or officials in charge of government hiring policies. Similar incentives produce similar outcomes in nonprofit organizations such as academic institutions, hospitals, and foundations, and different outcomes in profit-based businesses operating in competitive markets. Like decision-makers in regulated public utilities, those in nonprofit organizations were able to go along with whatever the prevailing opinions and pressures of the time might be, without having to worry about the costs created by discrimination too against minorities, which their institutions would have to pay. Against this background, it is hardly surprising that employment discrimination against blacks and Jews was especially widespread among colleges, universities, hospitals, and foundations until after World War II, when a revulsion against Nazi racism set in. Before that happened, however, there were 300 black research chemists employed in private businesses in the earlier era, but only 3 black PhDs in any field employed by white universities. As for Jews, they were seldom found on American college and university faculties before World War II. Although Milton Friedman had a temporary academic appointment before the war, it lasted only 1 year, despite high praise for his work by students and colleagues alike, and he spent the war years working as a statistician before eventually becoming a regular, tenured professor of economics at the University of Chicago after the war. At about the same time, the University of Chicago had its first black tenured professor. The University of Chicago was exceptional only in doing such things before most of the rest of the academic world. Decades later, after the political climate had changed considerably, colleges and universities engaged in preferential hiring of black faculty, as well as preferential admissions of black students, again, without the academic decision-makers paying any price for their decisions, just as they paid no price for opposite policies earlier. Affirmative action in academia was sooner and more sweepingly adopted than in private industries operating in competitive markets. All this happened too fast for such sweeping policy reversals in nonprofit organizations to have been due to changing personnel in the role of decision-makers. In many, if not most, cases, the same decision-makers who had discriminated against blacks were now instituting preferential policies favoring blacks. In neither case was the policy necessarily due to the personal beliefs, biases, or values of the individual decision-makers, nor was the change necessarily due to, quote, road to Damascus, end quote, conversions of political views occurring among innumerable decision-makers at the same time. Okay, that concludes that subsection. Our next read in Thomas Sowell's Discrimination and Disparities will be the subsection Unintended Consequences in Chapter 2. That would be Discrimination, Meanings, and Costs. And we should be able to, in our next read, finish up Chapter 2. So until then, this is Mike, signing off.